Good morning, everybody. Welcome to the Unitarian Universalist Congregation of Cleveland Sunday Morning Community Forum. My name is Wayne Jennings, and I'm the host of today's discussion titled, A Contested Presidential Election, What's at Stake? Given this subject, we hope to challenge you with new information about an election that could break America. If the vote is close, Donald Trump could easily throw the election into chaos and subvert the result. Who will stop him? As Unitarian Universalists, we organize these forums as a congregational service to the community to support personal reflection, social action, and to encourage individual and collective growth for all who attend. I'd now like to introduce the coordinator for today's forum, Ken Fries. He's a member of our forum committee, and he will introduce the topic and speaker this morning. Ken?
Okay. Welcome. We choose today's topic for this discussion because the results of the upcoming presidential vote may be contested. The incumbent president has promised to challenge the voting results if he is not reelected. So what may happen if the authority of the Constitution is not recognized and accepted for this election? So with that, I will introduce this morning's forum speaker, Dr. Jonathan Entin, who is Case Western Reserve Professor Emeritus of Law, Adjunct Professor of Political Science. Dr. Entin has taught many areas of law, including constitutional law, which is the root of our current discussion. He also served as Case Western Reserve's Law School Associate Dean for Academic Affairs. He has published hundreds of articles, book chapters, essays, reviews. He's received numerous teaching awards, including Distinguished Teacher Award from Case. Professor Entin was awarded the Juris Doctor from Northwestern University. He was a law clerk under Ruth Bader Ginsburg. Now, that's noteworthy, I hope. And Dr. Entin is in the law school, continues his research, writing on constitutional law, civil rights issues, and he also serves as a faculty advisor to Case Western Reserve Law Review. So we welcome you, Dr. Entin. Please proceed.
Thank you, Ken. It's very good to be with the Cleveland Uni congregation. I have very good, longstanding feelings about the church. The United First Parish Church in my hometown, the Unitarian Universalist Church there, dates back almost 400 years. Among its members were the Presidents Adams, both of whom, along with their wives, are buried in a crypt at the church. As we'll see, the Presidents Adams were involved in some contested elections, and I'll have a little bit to say about that in a few minutes. But on voting, I remember growing up that my parents were friendly with a woman named Dorothy Hill, who was a member of that church and who in her younger days had actively worked to secure the ratification of the 19th Amendment. Not from that church, but in the Boston area, James Reeb, a Unitarian minister, went to Selma, Alabama after Bloody Sunday, and he was murdered down there. That was one of the things that helped, unfortunately, to pave the way for the passage of the Voting Rights Act. Now, let me start the substance this morning by saying that I hope that what follows will be hypothetical, because they're not to give away the game, but from a legal standpoint, there are some constitutional and statutory provisions that matter, but particularly the statutory provisions, are ambiguous in some respects. They've never been tested. We're going to be figuring things out pretty much as we go along. Now, just to help put things into a bit of perspective, I have a timeline here that can help us put things into perspective. November 3rd, Tuesday, is Election Day. We know that an enormous number of votes have already been cast, but November 3rd is formally the Election Day. The next day that matters is December 8th. That is the so-called safe harbor deadline for having states' electoral votes presumptively accepted. We'll see that that's ambiguous. And then December 14th will be when the Electoral College meets in each state and cast their votes. Then on January 3rd, the new Congress will convene. On January 6th, we will have a joint session of Congress where the electoral votes will be opened and counted. And at noon on January 20th will be Inauguration Day. I'm going to try to proceed in a couple of different time frames. We're going to start with the period between November 3rd and December 14th, from Election Day to the Electoral College. Then from December 15th through January 6th, when the joint session of Congress takes place, and then what happens between then and Inauguration Day. Now, to get a sense about the legal pieces of the process, let's turn to the Constitution. The Constitution originally set up in Article 2 the procedure for choosing the president. And basically, what Article 2 says is that the executive power is granted in the president, and the president and vice president would be chosen through this process. Rather than a direct popular vote, each state will appoint, and I've highlighted in such manner as the legislature thereof may direct. We'll come back to this. This is a potential wild card, right? Each state shall appoint its members of the Electoral College. Basically, what this means is every state gets at least 3 electoral votes, 2 for their senators and at least 1 for the number of representatives that it has. The electors are chosen. Originally, they would vote for 2 people. And the person with the largest majority would become president. The person who came in second place would become the vice president. Now, if no candidate has a majority, the House of Representatives chooses the president. Each state gets 1 vote. And if there's no vice president out of this process, the Senate would choose the vice president. Now, this system worked well enough the first 2 times, in 1788 and 1792. After all, everybody understood that George Washington was going to become president. John Adams became vice president. Things began to come apart in 1796, which was the first seriously contested election under this system. And it took place against the emergence of the nascent party system. John Adams, the Federalist, became president. His leading opponent, Thomas Jefferson, the head of the Democratic Republican Party, as it was known, became vice president. To give you some sense about this, if that were the system we had in 2016, we would have President Donald Trump and Vice President Hillary Clinton. This system almost self-destructed in 1800. Then the problem was not so much which party won. It was clear that the Federalists had been repudiated, but rather which of the Democratic Republicans would become president, which would become vice president. And the problem was that the plan was to have Jefferson as president and Aaron Burr as vice president, but they came in tied in the Electoral College. The election was thrown to the House of Representatives. It took 36 ballots, and Jefferson was finally elected. If you remember Hamilton, the details are in that show are not strictly accurate, but you get the basic idea. Now, for what it's worth, the last time a presidential election was thrown into the House of Representatives was in 1824 when John Quincy Adams was elected president. Now, back to 1800. The country nearly came apart over that election, and so we got the 12th Amendment to make clear that members of the Electoral College would vote separately for president and vice president. If there was no majority for president, the House would vote. And if there were no majority for vice president, the Senate would make the choice. The only other change of consequence that occurred since the 12th Amendment was that in the 20th Amendment, the inauguration day was set at what it now is, which is January 20th. Now, if we flip back to Article 2, we'll see that Congress is given the power to determine the time for choosing presidential electors, that is to say, to set the election day, which we now have at November 3rd. By statute, election day is the Tuesday after the first Monday in November. As I said, that's the 3rd. The Electoral College Day, by statute, has been set as the first Monday after the second Wednesday in December, which means for this year, December 14th. And then there is also this safe harbor date that I mentioned, 6 days before the Electoral College meets. The point of the safe harbor day is to assure that each state's electoral votes will be counted if disputes over who gets those votes are finally and authoritatively resolved by that date. We will see, however, that we don't have a clear answer to the meaning of the safe harbor deadline. Now, this basic structure came in the wake of the 1876 election between Ohio Governor Rutherford Hayes and New York Governor Samuel Tilden. Tilden won the popular vote. He did not have a majority of the Electoral College. He needed 185 electoral votes. He had 184, but there were 20 disputed or 19 disputed electoral votes. The election was thrown to the House. The House couldn't decide, so it adopted an extra legal solution. It created a commission. The commission wound up splitting on party lines, 8 Republicans, 7 Democrats. That's how Hayes became president. In the wake of that controversy, Congress eventually passed in 1887 something called the Electoral Count Act. And we will be living under the Electoral Count Act if there is a controversy this year. But just to get a sense about how things might play out, let's start by focusing on what happens between November 3rd, Election Day, and December 14th, when the Electoral College meets. Now, if we have a clear outcome, if it's clear that one or the other candidate has at least 270 electoral votes, then pretty much everything that I'm about to say will be redundant or superfluous. But we know that there already is considerable controversy about which votes to count, who gets to vote, when the votes get counted. Right? We have controversies over ballot security, over voter harassment, over mail ballots that may come in after Election Day. Most states, including Ohio, have deadlines for when mail-in ballots have to be postmarked and when they have to be received. There's been litigation over whether those deadlines might be subject to alteration because of the pandemic. There also have been concerns about the efficiency of the Postal Service. Again, I don't want to spend a lot of time now on these things, but we can come back and talk about some of them. There also is a potential controversy. President Trump has been talking about this already, so have some other folks, about the possibility that the outcome in different states might change as votes get counted. In other words, on election night, it might look like the Republicans have an advantage in some places, but then as the absentee and mail ballots get counted, maybe the Democrats will have an advantage, and that could perhaps flip the outcome. The concern here is that Republicans seem to vote on Election Day more than Democrats do, whereas Democrats tend to vote more by mail ballot. That's the thought. So you can call this either the red mirage or the blue shift, but whatever it is, there is the possibility that what we see on election night won't be what the final count is. This is not totally hypothetical. In Arizona 2 years ago, the US Senate race looked like it had gone to the Republican candidate on election night, but when the mail-in votes were counted, it turned out that the Democrat had won. We've already seen suggestions from various Republicans that if we don't know the outcome on election night, everything that happens after election night will be somehow tainted. Again, we can talk a little bit about some of these things later on during the question period. Now, one thing to keep in mind, every state does have procedures for counting votes and for resolving election-related disputes. Typically, those matters get addressed in the state courts, but ultimately they could wind up in the US Supreme Court. This year, we've seen more than in the past, some election-related disputes have already been brought into federal court. If we have parallel state and federal court proceedings, we could, I'm a law professor. I think those raise wonderful, fascinating theoretical and jurisdictional issues. Again, not to get bogged down on them here. But in any event, it is possible that some of these disputes would ultimately wind up in the Supreme Court. Now, states presumably will try to take advantage of the December 8th safe harbor deadline. So they'll try to get their votes counted and a winner declared by then. But again, there could well be, and almost certainly will be, controversy over how the votes will be counted, which votes will be counted, how quickly they'll be counted. That could generate litigation and indeed That's how we got Bush against Gore in 2000. So here's the scenario that we should hope to avoid, but which we might possibly anticipate. Suppose that we have a swing state, Pennsylvania, Wisconsin, Michigan, North Carolina. Each of these states has a Democratic governor and a Republican legislature. We'll see that there's an interesting scenario in Arizona that I'll come to in a bit. But let's suppose that in one or more of these states, the governor concludes that Vice President Biden carried the state and certifies that his electors are the ones whose votes should count. And the governor does this by December 8th. But let's suppose at the same time that the state legislature, controlled by Republicans, concludes that Trump really carried the state. And so the legislature certifies Trump's electors by December 8th. Now, this could well happen. There's been a lot of discussion about this. And if this were to happen, then let me come back here to Article 2, Section 1, Clause 2. Each state shall appoint in such manner as the legislature thereof may direct. So the legislature will look at this language and say, the Constitution gives us the authority to decide that Trump's electors are the ones whose votes should count. Now, there is also some language in the Electoral Count Act that says if a state has failed to choose its electors on election day, its electors may be appointed on a subsequent day in such manner as the legislature may direct. So that's another point for the legislature. But we don't know what the word failed means. In other words, what does it mean to say that the state has failed to choose its electors on election day, right? Biden's supporters, if the legislature tried to act, would say that the legislature can't change the rules after the votes have been cast. That seems like a pretty good counter argument. Moreover, the safe harbor provision in the Electoral Count Act says that any law relating to the choice of electors must have been, quote, enacted prior to the day fixed for the appointment of the electors. That is to say, before November 3rd. And the Electoral Count Act also provides that the executive of each state shall communicate to Congress the election results and the final disposition of any dispute over those results, which leaves open the possibility, again, with both the executive and the legislature acting by December 8th, leaves open the possibility that some states could send two conflicting slates of electoral votes to Congress. Now, as I said, that could happen in Pennsylvania or Michigan or Wisconsin or North Carolina with a Democratic governor and a Republican legislature. It could also happen in Arizona, which, although it has a Republican governor and a Republican legislature, the Secretary of State, who is an executive officer and the state's chief election officer, is a Democrat. So we could even get this sort of scenario there. Now, however the legal arguments may play out, all of these matters go to Congress. Congress is not a court, and so it isn't necessarily bound by the kinds of approaches to interpreting statutes in the Constitution that courts are. Okay, now, so we have all these possibilities for conflict. The Electoral College meets on December 14th, and then And then the electoral votes are taken. With any luck, we'll have one set of electoral votes from each state, but we could have conflicting sets of electoral votes from some states. At that point, focus changes to Congress. The current Congress, with a Republican majority in the Senate and a Democratic majority in the House, goes out of business in early January. And on January 3rd, new Congress, the one that was elected in November, takes office. Just to get us back to focusing a little bit on how things will work, this is the provision of the Electoral Count Act that governs how the electoral votes will be counted in Congress. Now, I do not want you to try to read this. I will tell you that it is over 800 words long. It is one paragraph, and to say that it is inartfully drafted would be kind. So we could have lots of areas of potential dispute here. Okay, so under this Electoral Count Act, Congress meets in joint session on January 6th at 1 o'clock. As I said, the new Congress, Vice President Pence will be presiding in his role as President of the Senate. The roll of the states gets called in alphabetical order, and each state's returns are presented. Now, when a state's returns are presented, there could be an objection. Under the statute, the objection must come in writing. It must be signed by at least one senator and at least one representative. Each state then votes separately, or each chamber votes separately on whether to sustain the objection or to overrule the objection. If it requires both houses to vote separately to sustain an objection, if only one house votes to sustain an objection, the objection is overruled. But here and in each chamber, debate on the objection is strictly limited to 2 hours. There are limits on how many members may speak and how much, and for how long and how often. Now, if we read the Electoral Count Act, and it turns out that there are two sets of electors in our hypothetical scenario, there is some language in the Electoral Count Act that suggests that the votes certified by the governor are the ones that control. But it's not clear that that's the only way to read the language. And in any event, Vice President Pence in the chair will make the ruling one way or the other. Now, this raises all manner of questions. What happens if the vice president rules that the governor's slate is not properly before Congress because the Constitution says that the electors are appointed in such manner as the state legislature may direct? Another question, if, say, there's an objection to Arizona's electoral votes, do we have to get a resolution on Arizona before they can go on to Arkansas? That's not clear. If it turns out that there is a dispute over Arizona's votes, say, and we go on then to Arkansas and through to the end, well, the Arizona electoral votes will get put to one side. But then we have the question, do the votes that Arizona is entitled to cast, do they count for purposes of determining a majority in the Electoral College? Arizona gets 11 electoral votes. If all of a simple majority in the Electoral College is 270 out of 538, but if we put Arizona to one side, then there are only 527 electoral votes. So a majority would be 264. What happens if one of the candidates has 264 or 265 electoral votes, which will be more than the other candidate, but we have the uncast Arizona ballots. We don't know the answer to that either. Now, so those are just a few of the questions that we need to anticipate could arise. Now, let's suppose that there is some kind of congressional stalemate. Congress doesn't elect either a president or a vice president right away. Well, President Trump and Vice President Pence go out of office at noon on January 20th. Aside from whatever they might do when their term officially ends, federal law provides that the Speaker of the House becomes president if no one has qualified to be president. And the Speaker remains as acting president until someone else qualifies to serve as president. Almost certainly, we will see litigation in the event of a stalemate, but whether and in what circumstances courts might resolve those disputes, well, those are more really deep, uncharted waters. So let's back up. We can avoid all of this mess in a couple of ways. One, we get a clear winner on election night or a day or two thereafter. Two, we get a clear outcome in Congress. That is to say, one party controls both the House and the Senate, because at that point, the prospects for a stalemate between the two houses will be much less. But along the way, there is still plenty of room for mischief, and maybe worse than mischief. Neither the Constitution nor the Electoral Count Act provides clear answers to the questions that could arise with a seriously contested presidential election. In other words, we don't have a clear legal answer here. We have always managed to stay away from the abyss in the past, say in 1960, when there were claims that Illinois' votes for the Democratic candidate, Kennedy, were the result of ballot box stuffing, or 2000 with the controversy over Florida votes. In both of those situations, we backed off from the abyss because the losing candidate didn't press as far as might have been possible. Now, so these powerful norms about having a clear winner, a legitimate winner, operated in those years. It's not clear to what extent those norms retain their vitality now, and we have every reason to think that they do not retain their vitality. Bottom line, we could be facing the most fraught election since 1876. This is not a happy prospect, and I don't want to sound like an alarmist, but we do have the potential for some serious problems. Even if we get through election day and the following days and weeks, it's not like we're going to have everything fall into place. Our politics and our culture remain fraught because we have intense partisan polarization and social division. And whoever winds up in office after this election is going to have to try to make the best of that. So on that down note, let me stop and maybe we can open up for questions or comments.
Laura, are you there?
I am here.
Great.
Thank you so much, Dr. Entin, for that really informative discussion of a topic that's relevant and so important to us now. So I think I have a really interesting question to start off the question and answers. What if the states just refuse to release vote results until all the votes are counted? Could we avoid a lot of chaos and uncertainty?
Well, maybe, but the longer it takes to count the votes, this isn't a legal answer, right? The longer it takes to count the votes, the greater the likelihood that people will suspect something untoward is going on. Now, in Ohio, and I think in just about every other state, there are formal mechanisms in place so that the votes have to be counted with representatives from both parties present. But that doesn't always insulate the process from suspicion. I mean, you might remember the so-called Brooks Brothers riot in Florida in 2000, when a bunch of Republican supporters, most of whom were very well-dressed, professional-looking people, literally banged on the door of the election office while they were trying to count the votes because they suspected that the count was being manipulated in some way. We've seen enough claims about manipulation and fraud and things like that that if we have no returns released for several days, that will play into the suspicion that somebody is tampering with the results. So simply holding back all the results until all the votes are counted could be a real problem, especially because, let's take Ohio. In Ohio, mail ballots have to be postmarked by tomorrow, November 2nd, and they can be received as late as Friday, the 6th. But they won't all be counted then. And some provisional ballots won't get resolved for a week or 10 days after that. So we could be way into the middle of November, or maybe even almost to Thanksgiving, before we would have results released in Ohio. And for a lot of people, for enough people, that could provide sort of confirmation that somehow something bad is going on. Somebody's playing with the ballots. Even if, and I think this is true based on what I know about how the election boards operate in Ohio. I think the election boards in Ohio are generally really conscientious and will do everything that they can to make sure that they have a fair, accurate, and as timely as possible count. But I know that because I've seen how the boards operate. I know people on some of the election boards. I know the directors of election boards. Most people have no clue who's on the election board. And so the kind of basic legitimacy that the boards need may not be out there.
Dr. Entin, I think this is asking for a point of clarification. When you say the Electoral College meets, do you mean they actually meet in one room, in one place, either virtually or physically?
Okay. The electors meet in each state. Well, if we didn't have the pandemic, right, what would happen is that the Ohio electors would meet in Columbus on December 14th, and the electors in New York would meet in Albany, and so on. In other words, the electors for each state meet in one place. They cast their ballots. They get sealed up in an envelope, and they get transmitted to Washington, D.C. They get sent to the archivist of the United States, who takes possession of them and then delivers them to the joint session of Congress on January 6th. Now, it may be this year, because of COVID, that in each state, the electors will meet remotely. I don't know for sure how that's going to work, but the Constitution provides that the electors meet the electors for each state meet in that state, and that and they have always met in one place.
So state legislatures appoint electors who rely on popular vote. Could state legislators legally appoint electors different from the ones chosen by voters if there's an atmosphere of uncertainty?
Yes. In fact, as Article 2 was originally crafted, there was no requirement for a popular vote at all. And when the 12th Amendment was adopted, shortly after the 1800 election, again, there was no rule requiring that there be any kind of popular vote. It was only later in the 19th century that we got popular vote for presidential electors in every state. But if you go back and you read Article 2 and the 12th Amendment, there is no requirement that the people, any people, get to vote on presidential electors. The constraint on having the legislature simply come in and say, we are going to award our electors to whichever party is political. It's not legal. In other words, if the state legislature suddenly decided, notwithstanding, regardless of what the people may have voted, we, the legislature, want the electoral votes from our state to go to one candidate or the other. The constraint is that the voters at the next election will be so outraged that they will turn these folks out of office. But I'm not sure that you could get a court, say, to rule that the legislature had acted in an unlawful manner. I do think that there are respectable legal arguments based on the language of the Electoral Count Act that the legislature is not supposed to come in and change the rules after Election Day. But the Electoral Count Act is written in such an ambiguous way that that's not the only possible reading. And in any event, it's not clear that the Electoral Count Act overrides the Constitution in that respect. And the Constitution does seem to contemplate that the legislature could decide on its own which candidate gets the state's electoral votes. Again, these days, that sort of decision by the legislature could result in a big political backlash, but there might not be any immediate way to prevent that.
Well, speaking of the Electoral College, this question takes us back to sort of a historical perspective. Could you briefly explain why in antebellum America, slaveholding states opposed a direct election and favored the Electoral College?
Well, I'm not sure it was only the slaveholding states that were skeptical about direct election of the president. Remember that when the Constitution was framed in 1787, it's not like the franchise was widely available. I mean, the people who could vote back then were men, property holders, right? I mean, it was a very limited segment of the population. There was skepticism about giving the people, the voters, too much power, giving the general public too much access to voting. But if you look at the Constitution more generally, not only is the president indirectly elected through the Electoral College, senators were not elected by the people either. Senators were chosen by the state legislatures. And that was the rule until the early 20th century with the 17th Amendment that was ratified, I think, in 1917. So we have lots of reasons to think that the framers generally were skeptical about direct election of the president. Now, it is true that the slave states were concerned about maintaining their position and their power, and what we see with that is the so-called 3/5 compromise. That is, that the population for purposes of allocating seats in the House of Representatives was defined as free people, and then 3/5 of all other persons, right? The euphemism for enslaved persons. And the South wanted to have, the South wanted to count all enslaved people for purposes of congressional representation. The North, some of the northern states allowed slavery at that point. I think they all did, but slavery was not as common up north. And the northern states were concerned that if enslaved people were fully counted, that would give the South a political advantage. That's how we get to the 3/5 compromise. And we get to the Electoral College being allocated on the basis of 2 senators and the number of representatives, kind of as a grand compromise that's tied up with all of the other mechanisms for trying to balance the competing political interests of the North and the South.
I'd like to remind everybody that you can go to the Q&A button. If you're using a PC, it's probably at the bottom of your screen, but it could be to the sides or on top. So if you're using an iPad or a smartphone or some kind of tablet, it could be in the corner or something like that. So if you have a question, go to Q&A and type in the question, and we'll try to get to as many as we can. So, concerning the election process itself, are you concerned that a foreign power like Russia could breach the actual digital vote count?
Let's put it this way. I don't know enough about the technology to know what the chances of that might be. I mean, I suppose it's possible. It's possible that somebody inside the United States could maybe breach the vote count. I think it might be a little bit complicated. I don't know how this works in every state, but I know, for example, that in Ohio, the computers that are used to tabulate the votes are not connected to the internet, and so it might be a challenge for anybody to hack in. I don't know enough to know what the odds are, and I'm skeptical about anybody who says that there is zero possibility of something like that. But I don't know that we're talking about a really high risk.
There's a number of questions about what our current president, President Trump, may do right after the election. So one of them is this: what will happen if President Trump declares the election rigged and refuses to leave office and asks for support from his supporters who may be armed?
Yeah, okay. There's been a lot of speculation about that. And at some level, the question will be how much support Trump will have for such claims from other Republican officials, and maybe ultimately what the military will do. I mean, I hate to say that, but that may be the ultimate check. I mean, if the military concludes that Trump has not won the election and basically communicates to him that he's got to go, I mean, this is sort of the reverse 7 days in May scenario, where in 7 days in May, we're talking about a military coup. Here, we're talking about whether the upper reaches of the military would say to a president who refuses to leave office that he has to go. I'm actually less concerned about whether Trump will leave office or not. Again, I don't have any great insight into his thought processes. I'm actually more concerned about what happens if it turns out that Trump has lost the election. What happens during the interregnum, between the time that we know that the outcome and January 20th? There is lots of opportunity for mischief at that point. We actually have federal legislation about presidential transitions, but there's no way to force an outgoing administration to cooperate any more than we have any way of forcing an incoming administration to take seriously what they're being told. And there are a number of reports that after the 2016 election, when the Obama administration was trying to convey useful information, or what they thought would be useful information, to the incoming Trump administration, that the Trump people basically didn't pay any attention to it. So, there is a question about how the Trump administration as a whole will react if it is clear that they have been voted out. I don't have any information about the likelihood of these sorts of problems, but I think that those problems may be a greater risk, or that is, they may have a higher probability than Trump's refusal to leave. And they could have some significant consequences, because if we have no cooperation between the outgoing and incoming administration, then the incoming administration is going to be is not going to be able to know very much about what's been happening, and that will make it more complicated for them to start their own policies and programs.
There's concern about civil unrest, and I guess we could look at that from both directions. Depending on outcomes in certain states or in general. So in the case of civil unrest, can the president federalize the National Guard? Can he do this for all states at once? Does he have to be asked by state officials to come to their particular state?
Well, first of all, the president doesn't necessarily have to federalize the National Guard. The president could presumably do what could send active duty troops. There are legal limits on what the president can do in that regard, but again, it's not clear how those limits would be enforced. If the president does want to send troops or federalize the National Guard, that would have to be done, I think, on a state-by-state or case-by-case basis. Again, I don't want to push this too far, because there are some rules, there's some formal rules, but I'm not entirely sure how much those rules will bind a president who is bound and determined to act. But I can say that the president does not necessarily need the consent of say, a state governor or a mayor to send in either federal troops or the National Guard. And just to give a couple of examples, President Eisenhower sent the 101st Airborne to Little Rock to enforce the court order desegregating Little Rock Central High School, and President Kennedy sent federal troops to Oxford, Mississippi in 1962 to enforce a court order requiring the admission of James Meredith, who's the first African-American student at the University of Mississippi. In both of those situations, the president acted because the governor was standing in the way of the implementation of the court orders. In fact, in Mississippi, the federal courts had held both the governor and the lieutenant governor in contempt of court for blocking the desegregation. We didn't get that sort of ruling in Little Rock, but it was clear Governor Faubus had called out the National Guard to prevent desegregation. President Eisenhower sent the troops to enforce desegregation. And President Eisenhower did ultimately federalize the Arkansas National Guard. And when the federal troops were withdrawn about, midway through the school year, it was the Arkansas National Guard that was supposedly protecting the black students at Central High School, the same National Guard that had been there in September to keep them out.
This question goes back to the election itself. Republicans have deputized any number of poll watchers, some would say to intimidate voters on election day, particularly minority voters. And we know that in some areas there are open carry laws. Some of these poll watchers could have weapons with them. What should voters do if they see this happening?
Well, first of all, let's try to clarify where these so-called poll watchers are. Under the election laws, I think just about every place, certainly this is true in Ohio, each party gets to designate poll watchers who can be in the polling place in each precinct. But there's a limited number of those folks, right? I think it's like 2 people from each party. Now, what the questioner is asking about isn't those folks. Those folks have, the folks I'm just talking about have official status. I mean, the law recognizes those folks can be inside. They're not supposed to interfere with any voter casting a ballot, but they can be there to monitor what's going on. The so-called voter security operations that the questioner is asking about, those are folks who, at least in Ohio, and I think in just about every other state, are officially not allowed inside the polling station, and in fact are probably not even allowed within some buffer zone, 50 or 100 feet from the polling place. Of course, if you've got people who are out there carrying weapons, the fact that they're outside the buffer zone may not provide much reassurance. Now, there are a number of things that you could do, though, if you see a situation where somebody is intimidating or you think is trying to intimidate voters. Number one, in Ohio, call the election board. As I said, my sense in Ohio, at least, is that the election boards are pretty conscientious, and that's a first place to go. Second, there are organizations that are trying to promote voting rights. The ACLU, the Lawyers Committee for Civil Rights, the NAACP Legal Defense Fund. There are a number of organizations where they are prepared to go immediately to court if necessary to try to prevent problems. Now, it is possible that the open carry situation might be dealt with in some places by state election officials. For example, in Michigan, which is an open carry state, the Secretary of State ordered that people not be able to carry guns in close proximity to polling places. Now, there's been litigation over that order, and I'm not sure about the current state of that litigation, but certainly there, that is, that's a real concern. I don't know how widespread it is. Some of these things are more like they're more rhetorical than real. But let's put it this way: if you're worried that somebody with loaded weapons is going to be anywhere close to your polling place, and you're concerned that there is a risk of violence, some people are going to say, this is, this is not worth the risk. Some people may be deterred from voting, and that is a real problem. As I said, that's where there may be some mechanisms for dealing with this through, say, the election board or through some of the organizations that are trying to protect voting rights and have their own systems in place for dealing with these problems on a quick turnaround basis.
Here's a couple of questions you were probably expecting about Amy Coney Barrett. With her appointment, if the outcome of the election is determined in effect by the Supreme Court, how does Amy Coney Barrett's appointment in the court play out, and should she recuse herself?
Well, as Ken said earlier in introducing me, I was a law clerk many years ago for Justice Ginsburg, and so I'm not sure how much I should be talking about her successor or this entire process. But let's put Justice Barrett to one side. Let's go back to Bush against Gore. Bush against Gore was a more or less party line decision. I mean, it is true that Justices Stevens and Souter were appointed by Republican presidents, but certainly these days, most Republican officials would probably disown them if they could. So as I said, put Justice Barrett to the side. If we have a party line vote that essentially resolves the election, that's a huge problem. And frankly, I am not sure that this year the Democrats would respond the way Vice President Gore responded in 2000, which was to say, okay, the Supreme Court has made its decision. I accept that the Florida votes are going to go to George W. Bush, and that will give him a majority in the Electoral College. There were plenty of people in 2000 who thought that Gore should have fought on. It may well have been that if he had fought on, it would have been futile because the Republicans controlled both houses of Congress. So the outcome of the congressional elections might have some bearing on how, say, Vice President Biden responds. But I think that the Supreme Court has become such a contentious political issue that any decision that is seen as deciding the election will be greeted a lot more skeptically this time than was true 20 years ago. I don't know what that means in terms of changing the result. That is, if the court decides in a way that puts President Trump in for another term, I mean, then the question is, what can be done in the short term to prevent that? That's not entirely clear, right? But I think that we have already been in a fraught place politically in the United States. We've been getting there for a long time. This is good. This will be one more problem. That's why I said this year looks uncomfortably like 1876. We were less than a dozen years after the Civil War ended when that election took place, and there were real concerns that the country would go back to civil war over the outcome of that election. I don't mean to suggest that's a high likelihood here, but I think that we have a not very well functioning political system as it is, and if anything, will get worse if the Supreme Court winds up effectively deciding the election.
Dr. Entin, I'm trying to cover as many questions in the Q&A as I can. And in some cases, I feel you've answered the question pretty well. But here's one I just saw. This goes back to your original comments. Why would Pence preside over Congress January 3?
Well, because the vice president is the president of the Senate. That's defined in the Constitution. And so, although we will have a new Senate and a new House, or a partly new Senate and a completely new House on January 3rd, the vice president's term runs until January 20th. So Pence will preside over the Senate until January 20th, regardless of the outcome of the presidential election. But because his term as vice president continues past the convening of the new Congress, then he gets to preside. And the Electoral Count Act specifically says in the joint session of Congress that convenes on January 6th at 1 p.m., that the vice president presides and the speaker sits immediately to his left. I mean, that 800-word paragraph that I had up on the screen, I mean, it has all manner of details like that. Now, so that's the formal answer to why Pence will be presiding. But notice what an anomaly this is. I mean, after all, Pence is an interested player in all of this. Just as, let's recall, Vice President Nixon was an interested player in January of 1961 when Congress met in the joint session, just as Vice President Gore was an interested participant in January of 2001. That looks pretty strange, right? But that's the system that we have. Now, in 1961 and 2001, we knew there wasn't going to be a controversy because both Nixon and Gore had accepted the outcome earlier. But here, when by that point, it is possible that there will still be ongoing controversy about the outcome. And Pence will be directly affected by rulings that he makes, right? This does look really awkward, but this is the box that the Constitution and the Electoral Count Act have put us in.
What are the chances the election, this asks for speculation on your part, I realize. What are the chances the election will wind up in the House of Representatives? What do you think?
Well, it is mathematically possible. I mean, let us assume that all of the electoral votes are resolved without controversy. It is mathematically possible for there to be a 269 to 269 tie, which would put the election in the House of Representatives. That's about the only outcome, I think, that is likely to put it in the House. I mean, again, depending on how much controversy there is about the counting of the votes and the competing slates of electors. I mean, there are ways that we could wind up in the House there also. But if we wind up in the House, it is likely that Trump will be reelected because each state in the House, whether it is Wyoming or California, gets a single vote. It takes a simple majority of states to elect a president. If a state has an even number of representatives and they're equally divided, that state doesn't vote. Right now, so therefore it takes 26 votes in the House to get elected. Right now, I did a rough count on this a few days ago. Right now, I believe that the Republicans have more than 26 state delegations. So assuming that the House remain, even if the Democrats have a majority in the House again after this election, if the state delegations remain more or less the way they are now, the Republicans control more than a majority of the state delegations, and therefore Trump would be reelected. Now, in the Senate, each senator votes for vice president. it doesn't go by states. So whichever party controls this, has a majority in the Senate, would determine who the vice president would be. Now, if it turns out that the election goes to the House and the Republicans have enough states to reelect Trump, but the Democrats win a Senate majority, we could wind up with President Trump and Vice President Kamala Harris. So, I mean, that is legally, constitutionally possible. I mean, it is politically unthinkable, but it could happen if we wind up in a deadlocked election that winds up in going to Congress for resolution.
Well, I think our time has come just about to an end, and I think that's a very good last remark. I'm wondering, after hearing all the remarks people have made and the questions, if there's any last couple of remarks you'd like to make before we turn it back over to Ken.
I hope that we have a clear outcome. I think if we have a clear outcome, there's going to be a lot of bluster, but a clear outcome will prevent most of the real problems that could arise. Now, we could have plenty of mischief between now and the closing of the polls on Tuesday, but once that happens, as I said, if we have a reasonably clear outcome, then I think the rest of it will be mostly just atmospherics. But the last thing I said before I turn things over to you for the questions was, even if we have a really clear outcome, even if there's a landslide for both president and Congress, it's not like all of our political and social conflicts are going to go away. The election is an important place in our country. It's a date, it's a milestone, it's a landmark. But we still have to make the country work after the election. And the country faces enormous political and social challenges. And I hope we're up to it.
Thank you so much. And thank you everyone for your astute questions. We'll turn it back over to our coordinator, Kenneth Freeze.
Okay, thank you, Laura. Dr. Entin, thank you for your presentation. This potential contest sounds like it can be a challenge at many levels. And what I would ask is people that have logged in and listened to this presentation and have not been part of our emailing, on the chat box, you can add your name and an email, and it will be confidential. The next forum, which is November 8th, will be on journalism, and our speaker will be Brent Larkin. He's, of course, was with the Plain Dealer for many years, and he's spoken at our forum in the past. At 11 o'clock, we ask you, if you're interested, to join our congregational service. It will be the intersection between historical Unitarianism, Universalism, and the Day of the Dead and the Day of the Souls, which, you know, sounds appropriate. Anyways, I thank everyone for coming, and thank you again, Dr. Entin.
Thank you.
Wayne, do you want to add anything?
No, thank you, Professor Entin, and thank you, Ken and Laura. We're done. See you next week. I've got to stay on for a few minutes just to finish up the recording.